I want to just recognize, first of all, the University of Missouri Press, who published it. This is my 5th book, and my first one was by the University of Missouri Press. They're fabulous to work with, absolutely wonderful. I love working with them, so we really need to give kudos to the University of Missouri Press. I also want to recognize the Kinder Institute for Constitutional Democracy. It's part of their series, Studies in Constitutional Democracy, edited by Justin Dyer, who's on my board, and a good friend, Jeff Pasley. So I do want to recognize them. There's other books in this series, so this is part of a larger series. It is an edited volume, which meant I went out, I had the idea to do this, I've always wanted to do it. This is my state, this is my period, it has to be done, we can't ignore this. So I went out and located some of my best buddies, former colleagues in academia, and said, hey, how would you like to do something on this? I have read the debates in the House and Senate many a time. I even indexed them. How boring is that? And so that's the reason why they all said yes. I'm going to tell you that right now, because I said, here's the index. You get to do Article 4. Got it. Now I don't have to read it myself. So, and I'll just, when I get to some of these slides, I'll mention some of the folks here. So I'm going to hit the highlights of each chapter, because I don't want to give away the real story, because you're not going to buy the book. So hopefully there. I will say, if you would like a copy, one of the ways to get a free one is to become a member of Missouri Humanities, and you can go to our website, and this will be one of the gifts for membership. Otherwise, University of Missouri Press has copies, so let's just kind of move on. As I had mentioned before, the heart of this book is about congressional debates over Missouri's admission, 1819 and 1820, and then again with the Second Missouri Compromise until 1821. That's what we all looked at. We addressed this as if it was the ratification debates of the Constitution. Each colony and state has their own ratification debate. And that's what we looked at, the congressional debates, with that eye of thinking these guys they have not debated the Constitution since 1787, 1788 like they did in 1819, 1821. It was almost a second ratification debate. And nothing ever came out of it, and that's why we went to war in 1860. It's what happens when you don't resolve those issues. Now, there are some issues when you deal with congressional debates. If you go through them, I had just mentioned some of this. Gales and Seton were the reporters of the day. Problem is that you'll run across something like this. The first observations of Mr. L, and we don't know who that is, were lost to the reporter from the confusion arising from members changing their seats. Recorded one reporter. Mr. S made a few remarks which the reporter did not hear with sufficient distinctness to report them. The following must be considered as a free but not very full report. Other ones were in a 2-hour speech. They'll give a congressman's name and say, in his 2-hour speech, he opposed the Talmadge Amendment. Well, what did he say about it? You'd love that. Other ones, in a speech of more than 3 hours, or spoke for some time, or spoke at considerable length. So there are problems with that. But still, this is the best source, and there are copious speeches. And we're also lucky that a lot of these congressmen, after delivering a speech, will write more to it and go and give it to Gales and Seton, and they publish it. So there's other sources other than the Annals of Congress to find their speeches. One of the drawbacks of this, probably the most famous individual of the Missouri Compromise is Henry Clay. We don't know what his speeches are. We can only glean them from what other congressmen say. So, did he do that on purpose? I don't know, but he was, as a Jacksonian, I don't like him, let me put that way, but he is wise and he got us into the Union. So, let me get going on this because I just kind of want to summarize the book tonight. The Missouri admission crisis is a constitutional crisis par excellence. Yes, slavery was involved, but it's the means to the end, if you will. It was about the Constitution. Slavery was that part. But the question is this. Basically, does Congress possess the authority to place conditions on a territory in order to be admitted into the Union as a state? That's it. That is all the debating is about. It's not so much about do we want slavery or not. It's mostly about the spread of slavery across the Mississippi River. But this is the debate. Can Congress tell a territory, you must do so-and-so if you want to star in that flag? And it's erupted into the Missouri debates. In this case, what is that condition? What is that stipulation? It is the Talmadge Amendment, which you can read here. In fact, I got it here, and it'd be a lot easier if I didn't turn and look at that. But To limit slavery west of the Mississippi, provided that the further introduction of slavery or involuntary servitude be prohibited, and that children all born within the said state, Missouri, after the admission thereof into the Union should be free at the age of 25 years. This is not abolition, this is what we call emancipation. It is gradual and over time, okay? They don't want, there is slavery in Missouri. It is a slave territory and will become a slave state. But it's the further spread of slavery into the territories that we acquired from Louisiana Purchase. Okay? That is the issue. That's the crux of this whole issue. And so, does Congress have the power to put this amendment on the Missouri bill? No other state has such a thing. Do they have that power? And that's where the real debate will erupt. So in our book, I believe there's 7 chapters. I wrote the introduction and 2 chapters, and the colleagues each wrote another 4 chapters. Article 4 of the U.S. Constitution was the big one. They tore Article 4 apart. That's 4 chapters in this. And it's kind of I don't want to get too much in the Constitution, but that was, when they created the Constitution, there were a lot of debates about what does Article 4 really mean. Now, for the first time, we're arguing about it. We're trying to resolve, what does Article 4? Because it's not so much about Congress. It leaves a lot of things open. Is it the states, the people? We don't know. And so now we're going to debate this for the very first time. So one of the chapters is on Article 4, Section 3, Clause 1, the powers to admit new state. And it clearly says in the Constitution, new states may be admitted by the Congress into the Union. Well, what's the problem with that? Oh, the operative word, may. Will, can, should. What the heck does may mean? So that's the first issue of this. We're actually arguing about words. So keep in mind, I'm going to use a term tonight, restrictionists, because that's what it's about, restricting slavery in Missouri. So the friends of the Talmadge Amendment were restrictionists. They wanted to restrict the spread of slavery. Those who opposed the Talmadge Amendment were anti-restrictionists. So I'm going to use those terms. They did not want any type of restrictions. And a lot of times, you got to be careful, it had nothing to do with slavery itself. It had to do with economic factors. So there's a lot here, more to this story. My good friend John Van Atta, he wrote probably the best book out there today on the story of the Missouri crisis, The Wolf by the Ears. Hopefully he's not listening, he'll get after it. But it's a great book if you go read it. It's a fantastic summary of the entire crisis. But there's other things in this phrase that Congress debates. It says nowhere in here that they have to admit a state on the equal footing with the other ones, does it? Now we know all states come in on equal footing. They put that in the Missouri bill for a reason, because it doesn't say it in the Constitution. Do they come in just like the original 13, or the ones existing at the time? The other, it'll make up 23. We don't know. It also does not literally preclude placing stipulations. It doesn't say Congress can't put a stipulation on it. Either way. So do we read the Constitution literally? So it's another issue they're going to debate back and forth. This is where Congress becomes fantastic historians. Or maybe not very good ones, because they're doing it for political purposes. But every congressman arguing for or against using this article, they have to go back and they have to look at the admission of previous states. Were other states entering the Union, did they have conditions on them? And those who are against the Talmadge Amendment said, no, Congress never did that. And those that for the Talmadge Amendment, yes, they did, and here's the proof. And then the anti-restrictionists will have to counter. I'll give you an example. The Northwest Ordinance, 1787. Is that a condition? So when Ohio, Illinois, Indiana, Michigan, and Wisconsin come in, slavery is supposedly prohibited. Congress passed that. We know that's not exactly what that means. And some states had slavery. Illinois did 1839. Michigan Territory to 1794. But is that a condition? But who does that apply to? Only the Northwest Territory. But a lot of congressmen will argue there is no other model to enter the Union. Keep this in mind. We come out of 1803, the treaty with France. That's what Missouri is going to come out of. And at that time, the only measure of entering the Union is the Northwest Ordinance. So they say it applies to Missouri. But we also know Kentucky, Tennessee, Eventually other southern states come in before Missouri. Were there conditions placed on them? Nothing about slavery. They can come in with slaves. They knew Tennessee would and other states would. And there were some minor conditions, such as a debt, some land issues, things of that nature. But this is powerful. This is slavery. Why? Because it's property. That is a powerful argument. So both sides are right, and actually both sides are wrong. You could have a congressman argue about examples of Tennessee and Kentucky coming in with restrictions and no label. And you could have another congressman come back from Tennessee and Kentucky and say, no, that's not what you're talking about. The Talmadge Amendment's different. They were brilliant. No side won these arguments. And you know what happens when that happens? You go to war, and we will eventually, over a lot of these issues that are not resolved. I'll just give you an example of Georgia. When Georgia relinquished what is today will become the Mississippi Territory, which is northern Mississippi and northern Alabama today, and then eventually the southern parts that we get from Spain in 1795. When they relinquished that, they told the federal government, we're not giving up our western lands unless you stipulate that when these states come in, yada, yada, yada must happen. And Congress did that. Are those stipulations? Technically, they're placed by Congress because they agreed to what Georgia wanted. And Georgia will get mad eventually because they're not followed. Admitting a new state in just one sentence is so powerful. It means so much. And so if you want to read some great history, read John's chapter on there because it's wonderfully written. And you'll think again about the Northwest Ordinance. You'll think again about the states entering the Union. And I'll just give you another example. We'll enter technically 1820. We'll recognized by the federal government in 1821. What state entered in 1819? Well, all this is going on. These bitter debates. Alabama, with slavery. And James Talmadge Jr. voted for the admission of Alabama. We'll come back to that in a little bit. Why do they get to come in? With nothing, no words about slavery. Why isn't there a stipulation put on them? We'll kind of come back with that in a little bit here, in another section here. My good friend Chris Childers, his chapter, he actually has two in here. Article 4, Section 3, Clause 2, the power to regulate territories. Another section of Article 4. Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. Wow, that's powerful. Territory. States are sovereign. So that becomes an issue for those who oppose the Talmadge Amendment. Yeah, we can make all the needful rules and regulations for territories, but we're talking stipulating something for a state, and you can't do that. States are sovereign. They will determine whether they want slavery or not. The other word, rules and regulations. Well, that's not, the Talmadge Amendment's not a rule or a regulation, but then others will come back and say, property. Our slaves are property. So there's back and forth because a lot of Northerners don't see slaves as property. Now they're arguing it is, just to get the other side. And then Southerners will say, wait a minute, that's not what I meant by property. So it's all political. But states are sovereign. Congress cannot legislate regarding slavery. It's a domestic institution. It is under municipal law, which means state law, local law. Always has been, always will be. So therefore, Congress can't touch that part of it. So they'll argue back and forth. One of the larger questions of this, and it's in the introduction in here because it's not so much an actual article that's debated. Does the Constitution recognize slavery? Is it protected by the Constitution? Or does it have nothing to do with slavery? Major arguments that underlie all of these. If those who say, and both sides, there are many of those in the North, in the Free State, yeah, there is slavery in there. It's not explicitly said. We'll come to some of those terms here. We all know what it means. But no, the federal government does not protect slavery. Otherwise, there are a fugitive slave clause. Oh, crap. I mean, it just goes back and forth. And they never resolve that issue. About 400,000 dead will later. The next one is here. That was another debate. The other article section, Article 4, Section 2 clause, the Privileges and Immunities clause. And this comes out really in the second compromise. So just to let you know that we really entered the Union March 6th, 1820. We all know that. I have to say, we had to put that on our flag. Not 1821, August. Why do they have that? President Monroe signed the Missouri Bill becomes a law, and Missouri is in the Union. We're now empowered to draft a constitution, write a constitution, create a state government. And we did. And operated a full first General Assembly for a full term. Elected a governor, lieutenant governor. Sent 2 U.S. senators and a congressman off to D.C. The reason we weren't let in is because of our Constitution. There was a very powerful clause in there that, quote, that the General Assembly could pass a law, quote, to prevent free Negroes and mulattoes from coming into this state and settling upon any pretext whatsoever. Well, for the North, they thought, hot damn, we got another reason to keep Missouri out. And then started a whole other, we were not allowed to sit. Benton and Barton and Scott, they were not allowed into the halls. In fact, it's kind of funny because when they did the roll call, John Scott, who's our delegate, refused to recognize when they called the delegate from the territory of Missouri. Would not answer him. Because I'm a congressman. You can call me that. No, we're not. You're not in the state. So there's a lot of these issues. But does that violate citizens of each state should be entitled to all privileges and immunities of citizens of everything? If you are a free black in Massachusetts and you can't go to Missouri, does that violate the Constitution? Okay? The North's going to say, yeah, it does. They have the same privileges and immunities as in Massachusetts, Pennsylvania, as in Missouri. Okay? But that's really the second compromise with the Constitution. There's a lot of powerful stuff in there. But it's also the first compromise because it's the right to own slaves. Keep that in mind. If I have a right to own slaves in Virginia, by God, I can move to Missouri and own them there as well. So this becomes a powerful argument because technically there are no free states. If I am a slave owner and I have all the privileges and immunities in Virginia, would I have those in Illinois? Powerful arguments. And they will say, technically, under the Constitution, Article 4 here, Privilege and Immunities Clause, there are no free states. Now, nobody's going to really test that at the time, but Missouri is a different thing. And so there's another powerful argument. John Eastman, a good friend of mine, did the Guarantee Clause. The United States shall guarantee to every state in this union a Republican form of government and shall protect each of them against invasion and on application of the legislature or the executive when legislature cannot be convened against domestic violence. So this was a powerful, how could this be one of the biggest arguments? What does Republican form mean? For those who favored the Talmadge Amendment, for those who were going to vote for that, slavery is not Republican. We are not a republic because of slavery. Powerful argument. In response to that, those anti-restrictionists, those who did not want the Talmadge Amendment passed, kind of argued the exact same thing, or the opposite. Well, I don't want to say that slavery is part of Republican government, but name me a republic that was not based on slavery. You can kind of hear a pin drop. We were always a republic, and we had slavery. Someone would say they go back to the Dutch, English, they all had slavery. You go back to Greece and Rome, oh, the heart of democracy, they had slavery. So how is it not Republican? No one ever resolves that. Well, until 1860s. The other part of this I kept on, this is how, you have to read the book to get further into some of these phrases. The last part. Why was that? On application of the legislature and executive, to protect us against invasion or domestic violence? What is domestic violence? We think Civil War uprisings. What is the most feared uprising prior to the Civil War? Slave rebellion, slave insurrection. So South Carolina and its governor can call the federal troops up to suppress the Denmark Vesey or whatever some of these rebellions are. You bet. So you got soldiers from free states coming down and suppressing slavery, and technically re-enslaving those who rebel. Is that not recognized by the Constitution? Doesn't say slavery, but that's the main the domestic violence issue. So that's powerful stuff here. So now, if Congress has the power to put down slave insurrections, it has the power then to limit the spread of slavery. See that argument? It's powerful. And then those who are against it, against the Talmadge Amendment, will come back and have a whole different argument. And I'm not going to tell you all of them, because you got to go read the book. So that was Article 4. Those are the 4 main parts. There's 4 chapters on there. A good colleague of mine, Brooke Poston, I'm not even sure he is. He was at TCU. I think he's at Stephen F. Austin now. He wrote a fabulous biography of James Monroe. Came out a couple years ago. So if you want to know, probably the best book written on James Monroe. And that's the reason why he's in here, is because Monroe's president on this. And don't think for a minute the Monroe administration and the cabinet's going through the same thing. And their debates is also in the book, in the introduction, about what do they say about it. And it's not what you think. Some of the slave owners, Calhoun and John Quincy Adams, really agreed with each other. That's crazy, because they're going to hate each other here in about, 2 more decades. So the 3/5 clause. This is really what it was all about for Northerners. Come on, guys. Some of them probably hearing this going, nah, it's not true. Yeah, it is. For the North, especially New England, they despise the 3/5 clause, which means for reasons of taxation, representation, Congress, the Electoral College, we can count 5 of our slaves as 3 people. And that was a compromise at the Constitution, one of the main ones. Now the South wanted to count all the slaves, and then the Yankees go, no, 0. They're slaves. And of course the slave owners go, we count women and children. They can't vote, but they're not slaves, they're not property. So we're never going to resolve anything. But keep this in mind, for those in New England, they despise the 3/5 clause. They're trying to get this out of the Constitution. During the War of 1812, the Treaty of Ghent, or actually Andrew Jackson's victory in New Orleans, kills the Hartford Convention, that movement. They want to alter the Constitution to get rid of the 3/5 clause. And the reason for that is because it gave the South political power, more preponderance in the halls of Congress and in the White House than the North, because the Southern population is elevated. And keep this in mind, if you go from George Washington, definitely up to the 1850s, they're all Southerners. 2 Adamses. And Van Buren doesn't count. But basically, you've got the Virginia dynasty. Jefferson, 2 terms. Madison, 2 terms. Monroe, 2 terms. They're tired of this. No more Virginians, but they had the power because of this 3/5 clause. So this was the real reason for the Talmadge Amendment. Because if Missouri no longer has slavery, the 3/5 clause does not give the South any more power. If you stop the spread of slavery past the Mississippi River, if you stop it altogether, Louisiana Purchase, no state can come into the Union with slavery, and therefore the power of the South will dwindle. Don't think for a minute that Southerners are going, oh, that's a powerful argument. We got to keep the 3/5 clause in there. It's got to have slavery in Missouri. So there is a political battle there. I do a lecture, and if you ever want me to do it again, it's actually, I think one of my more fun ones. I did it for the Missouri History Museum, and I think they have it in their video archives. But it was, what did anti-slavery mean in 1820? And it's not what you think it is. One of the great historians, who I actually wanted to study under, long ago, considered the Talmadge Amendment white men's egalitarianism. That's what it was about. And I got some powerful quotes from dozens and dozens of Northerners, Free State, who were big proponents of Talmadge Amendment. But they only wanted slavery gone, but no blacks. No free blacks. And they'll say it, they'll state it strongly. This will be a white man's world on the other side of the Mississippi River. Free labor, free soil will come out of that later, the Free Soil Party. This is the beginnings of that argument. But the 3/5 clause has to go. And that's what they're going to argue. Now we know the Constitution gets rid of the 3/5 clause. Or the Civil War gets rid of this part of the Constitution. But underlying this, and there were some that are very frank about it. Some of the top leaders, King in the Senate, for example, of New York, pretty much said, yeah, you bet this is what it's all about. We're tired of this. We're losing population westward. Every state that comes in the Union is a Jeffersonian Republican. All of them. And now it's going to keep on going. So we got to get rid of this clause. That's a way, if you can't get rid of the 3/5 clause, we need to have the Talmadge Amendment. Because slavery goes away, and this is watered down. So powerful argument there as well. And he does a great job, Brooke does on that one as well. And I'll leave questions if you have any here to the later. That's the problem about streaming. You can never get the questions from audience. One of my favorite ones, and I did write this one, is the Migration and Importation Clause. Something you don't even probably know is in the Constitution at all. And the reason for Article 1, Section 9, Clause 1, that you don't know about it is because the Civil War automatically killed it. This is just powerful stuff. Let me just start with this. What does such persons mean? So, for those who want the Talmadge Amendment, we know exactly what such persons mean. Slaves! Not necessarily. Could this be read to include free white immigrants from Europe as well? Oh, because they'll do that here. Very powerful. Let's come back to such persons. Importation. Really nobody argued with that. Importation. We know what that means. You're importing slaves. Okay? But what does migration mean? Now, for those who wanted the Talmadge Amendment, migration applied to such persons. Blacks. We can regulate the migration of slaves through the country. Pretty good argument. Now, for those who despised the Talmadge Amendment and voted against it, migration applied to whites. Some would say it was actually a bargain with New England. They want, what's the country want more than anything in our earliest stages? People. We want to move westward, develop, conquer the land, build. We don't want any restrictions from Europe. And so this was a way that Southerners said, fine, you don't regulate the importation of slaves, we won't regulate the migrations of whites. That's actually an earlier argument. It's powerful. But the other thing is that some will say also you can't import white people. They're migrating here. That applies to whites. Another argument that kind of flipped that, where it says a tax or a duty may be imposed on such importation. Well, there's no tax and duty on migration, is there? Because you can't tax and duty a white person, a free man. So it's like, oh, there's an argument there, darn it. And then think about that one. So we know importation means slaves. And hence, that's the reason we don't say slaves, because we can't. It's such persons. Another argument in here says, this is powerful too, to admit, just that phrase, to admit. I wrote a biography of Philip Pendleton Barber, who was who died on the Supreme Court, but he was under Jackson. But he was also a leading congressman, Speaker of the House for a while, right after about 1821, 1823. He was one of the more powerful anti-Talmadge Amendment speakers. He's phenomenal. And he picked up that he's a lawyer, that's the reason, to admit. Okay. It's powerful. You admit people into the Union. You don't admit them from state to state. Once they're admitted, they're already here. Well, yeah, I guess you're right. Kind of powerful, you know. What does this mean? Now, I will say this in this book too. All of us do give the background to this. We will go back to the Constitutional Convention. What did the framers in Philadelphia think about these? What did they say? And then especially, what did the ratification debates say about this? And you can go back, and migration is not in there. Not until the very last day of the Constitutional Convention do they change it. It would always read importation. And suddenly, I don't know if the Anti-Federalists caught it or not, or whatever, now there's migration. So we don't know. A lot of these founding fathers, we don't know, we just stuck them in here. They're not thinking this is going to happen, for one. But to admit, people are admitted into a country from another country. They're not admitted into one state from another state. They migrate. So it applies to free whites only, whether coming from another country into ours or from state to state. Migration does not apply to blacks, and therefore the Talmadge Amendment cannot happen because Congress does not have the authority to levy it. There's another phrase in there, it's pretty powerful. States now existing. This is the Constitution. That means 13. Does it apply to the states that came in afterwards? Does it apply to Missouri? Was Missouri a state now existing? No. The migration and importation of such persons as any of the states now existing. That's 1787, 1789. Let's go right with that date. Our first government. So it does not apply to people that said, no. Whether you think this is or not, no. We can do the Talmadge Amendment because it has nothing to do with the original 13 states. Of course, others argue, well, why didn't you do it for the other slave states? Well, we didn't. Too bad. We're doing it now. We could have. We just didn't. So it's powerful. So you can see how they're arguing over every little word and phrase. And they'll go on in days and days and hour speeches on words. What do they mean? On phrases. And each side will argue the same thing. And no one comes away convinced at all. I remember a lot of congressmen saying, we are beating this to death. But I'm going to get them to talk about it. They will start off that way. There's nothing more to say, but here's my 2 cents. So that's in the book too, that they knew this, there's nothing more to say. No minds are being changed. The votes are essentially all the same every time. So that's another powerful one. Article 2. By the way, that was Article 1. Article 1 is Congress, legislative. The reason for Article 4 we don't know who's that apply. Federal government, states, whatever. Article 3 is the judiciary. Article 2 is the president. Treaty-making powers. This is another one that I wrote, and it ends off. I mean, come on. How do the treaty-making powers have anything to do with this? And it's kind of funny because there was a lot of controversy when Jefferson got the Louisiana Purchase. Everybody pretty much knows that. Because there's nowhere in the Constitution say that the United States can acquire foreign territory. Especially by, treaty-making. It doesn't say it. So if you're a literalist, can't do it, but we did it. And we're lucky for it. But part of this, he wanted a constitutional amendment. And it's a fabulous constitutional amendment because we'd have never had this problem. Because it has said, all white inhabitants, and that's the words, I can't even remember what the rest of it was, but will enter the Union. They can take care of slavery how they want it or not. The amendment never passed, we know that. So now we have this stuff. So treaty-making powers. The President shall have power by and with the advice and consent of the Senate to make treaties, provide 2/3 of senators. What's that have to do with the Talmadge Amendment? Well, it really has to do with Article 3 of the Louisiana Purchase Territory. Inhabitants of the ceded territory shall be incorporated in the Union of the United States and admitted as soon as possible according to the principles of the federal Constitution, the enjoyment of all these rights, advantages, and immunities of citizens of the United States. And in the meantime, they shall be maintained and protected the free enjoyment of their liberty, property, and religion which they profess. Oh my. I'm just going to tell you 6 things, not the full 10 to 12, about this. How does this say Congress does not have the power? Or does it? All right, so first of all, let's deal with this. Shall be incorporated. What the heck does that mean? For the Southerners, it's like, you got to be in the Union. For those in the North, no, they became a territory. You're in the Union. No. The only way to enjoy these privileges and immunities is through statehood. If you're a territory, you aren't guaranteed those. So you have to be incorporated into the Union as a state. The territory thing just ain't going to cut it. Admit it as soon as possible. That's the reason the South's saying, get Missouri in the Union. It says it right here. We're going to follow this treaty. Admitted as a state as soon as possible. And the North said, that's not what it means. As soon as possible means when you have met all the requirements to gain statehood, which is, there's 3 stages you got to go through. You got to have 60,000 people population before you can apply for a statehood. Well, Missouri did. Well, not always. So it's not as soon as possible. It's when you're ready to follow the rules and regulations. But keep this in mind. This is very powerful here. For those in the North proposing a Talmadge Amendment, why they opposed this treaty at this time is because they're in the House of Representatives. Who makes the treaties? The Senate and President. Who's left out? The House of Representatives. But what power does the House of Representatives have? We may admit new states. So what trumps? Remember, a treaty is the supremacy clause. It is the supreme law of the land. So if that's the case, you can't pass the Talmadge Amendment because a state constitution with the Talmadge Amendment can't trump a treaty. And this treaty here declares you can't pass the Talmadge Amendment. You can't touch slavery in Missouri. Unbelievable arguments. So another one, I'm going to go in the order of how they have it. Principles of the federal Constitution. What's that mean? Here is a grand debate. Slavery is not protected by the federal Constitution. It's a beautiful debate by the proponents of the Talmadge Amendment, and it's true. And then the Southerners will say, in truth, sure it does. It protects me in Virginia. What do the principles of the federal Constitution? Now, for those who oppose the Talmadge Amendment, it just means we're going through the 3 steps. They did it. That's the principles of the federal constitution, let them in the Union. No, because they'll get to citizenship. It's just the nature of owning slaves because of this. And some of the Northerners even say, because you are a slave owner, we're not following federal principles. They don't apply here. So that doesn't mean slavery or not. Enjoyment of all these rights, advantages, and immunities of citizens of the United States. Well, again, for those who want the Talmadge Amendment, says that we're not violating anything. People in Missouri have all the rights, advantages, and immunities of citizens of the other states. Because slavery is not a federal citizenship. It's a state. Only a state determines slavery or not. So it has nothing to do with the federal constitution. It has to do with states. So therefore, those folks in Missouri, they got all the rights, privileges, and immunities. It's guaranteed. In the meantime, they argue over in the phrase, in the meantime. And those proponents of the Talmadge Amendment really push this way. It's a fabulous argument. And of course, property. There's the big one. Slavery. Property. And those for the Talmadge Amendments, that's not what that means. And I was going to go over, I don't want to pull some of this out, but here's a grand argument for this. For those who proposed the Talmadge Amendment, none of this applies to Missourians. This applies to the residents, the inhabitants of the ceded territory only. Missourians are not inhabitants of the ceded. We came later. So you can only protect the property of slaves of French. The settlers that were there the day Napoleon gave us the ticket. That's who it applies to. It does not apply to Americans coming in and bringing their slaves. They can't have slavery. This does not protect them. It only protects the original inhabitants. Powerful argument there. And then for those from the South, will come back and go, okay, how about this? Have you ever heard of the state of Louisiana? 1812? Nothing restricted there, and it's slave. So how's that different than Missouri? So nobody wins in any of this. Just to kind of sum up, because I want to get to questions here. The other big argument on the treaty-making powers, if you look at this map, this is 1783. This is the end of the American Revolution, the Treaty of Paris. You can see that England gave us pretty much from the Great Lakes to the Gulf of Mexico, from the Atlantic to the Mississippi River. Okay. Missouri is not American. It was acquired territory. And nowhere in the Constitution does it allow us to acquire territory. Therefore, Congress, for those from the North, has the power and authority to do anything we want with acquired territory. And the Talmadge Amendment should be passed. We have that authority. Missouri is not original. And that becomes a very powerful issue, because keep in mind, when they do pass the Missouri bill, it will say explicitly that Missouri is coming on equal footing with the other states. This is a powerful argument, because a lot of Americans in certain states didn't believe other states were equal. Not to the original 13. So therefore, we can't stipulate to them. They're not us, the original. And in fact, not only did they not come out from England, which is the original United States, they're foreign. Just because we acquired a foreign territory, we have full power over those states. So obviously, the other side will argue differently. There's so many other powerful issues on here. Throughout all of these arguments underlying this is that strict construction versus implied powers. How do you read the Constitution? And I do have a phrase here. Obviously, for the most part, those pushing the Talmadge Amendment, well, read it somewhat liberally. Whereas many Southerners are reading it strictly. You can't do this because it doesn't say you can. Okay? But what I did want to read is the last one, the treaty-making powers, just to give you an example of how political these guys were. In the end, the congressional debate over the meaning of the interpretation of Article 3 of the 1803 Louisiana Purchase Treaty, treaty-making powers, ironically exposed an ideological flip by the contending parties, restrictionists and anti-restrictionists, as to how to interpret the Constitution, whether through a broad or strict construction. On just about all other arguments involving constitutional authority and power during the Missouri debates, opponents of restriction usually employed a strict interpretation of the Constitution, while the proponents of restriction often assumed a more liberal interpretation, but not so when it came to arguing the treaty-making powers of Article 3. When interpreting the various phrases, terms, and words of that Article 3, foes of slavery restriction tended to take a liberal approach. Friends of slavery restriction, on the other hand, applied a far more literal translation to the Constitution. Fun stuff, huh? I mean, these guys are real politicians, but they're going to make their point no matter what. The General Welfare Clause, Article 1, Section 8, Congress shall have the power to lay, collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. Well, a lot of people say because of the General Welfare Clause, they just read it, Congress, Talmadge Amendment, we have the power to do that. And so those in the South, I didn't see it. Well, where does it say that? General welfare. We have the right to do whatever we can for the general welfare of the United States. And for Southerners, like the Jeffersonians, there's no comma or there's no semicolon in here. That's one sentence. You can only power, lay, collect taxes, duties, imposts, and excises for the general welfare. It has nothing to do with it. You don't have a general welfare power. Okay? The next one's the necessary and proper clause. At the end of Article 1, Section 8, where it says, all Congress shall have the power to do yada, yada, yada. It says, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested in the Constitution. For those who literally read the Constitution, no. You can only do what's necessary and proper to carry out those little things that were just before here. But if you read it more liberally, well, we can pass all laws which are necessary and proper for carrying out the Constitution. And therefore the Talmadge Amendment, it's right there in our hands. The 10th Amendment became the anti-restrictionist fallback. 10th Amendment, it's not in the Constitution. 10th Amendment states, you can't do this. The 10th Amendment prevents it. Prevents Congress from ever putting stipulations on a state. The Commerce Clause came into play. Okay, keep in mind, this is the great age of the Marshall Court coming out here a little bit. The Commerce Clause. It's in there, Article 1, Section 8. Congress has the power to regulate commerce. What's that have to do with slavery? That's commerce. It's property. Oh, say the Southerners, man, they got us on that one. But no, the Commerce Clause will not deal with regulating slavery. That's not what the Talmadge Amendment does. And of course the Preamble, and this is powerful here. We all know the Preamble, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for common defense, promote the general welfare and security, bless liberty to ourselves and our property, do ordain and establish the Constitution of the United States of America. It's a preamble, it's an introduction. Hey, this is what we're doing here. During the Civil War, there's an unbelievable new argument. It's called the Adequacy of the Constitution theory. Timothy Farr, William Whiting, or some of the scholars writing on this. They will argue that the Preamble empowers Congress to do anything it so desires. And the Union's going to pick on that. The Lincoln administration did. Nope, the Preamble. We must save the Constitution, and therefore the Preamble gives us plenary power to do. We can do anything. We don't have to ignore all the other sections in there. This is the first time they use that argument. Some of the free states, because of the Preamble, we can limit slavery. The whole nature of the Union, confederation or consolation. Are we a consolidated government? Is the federal government, the central government, the most powerful? Or are we a confederation of sovereign states? The whole nationalism versus states' right is part of this too. The location of sovereignty, where is it? For those who want the Talmadge Amendment say, the federal government, we're supreme. Those who oppose the Talmadge Amendment say, no, states are supreme, state sovereignty. You can't do the Talmadge Amendment. That's Missouri's role in all of this. And then, of course, a lot of people will say popular sovereignty. It's up to Missouri whether it wants to be slave or not. So, some of those arguments. And of course, and I'll end with this, you guys, this is fantastic. They used history, they dug up political theory, thinkers, biblical authorities. I put in the introduction. They brought up hundreds of different individuals from history. These were some great historians and political theorists. Federalist papers really, come out during this one. No one, I think, ever mentioned Federalist 10, which is most famous. I think like 42 and 45. And by the way, both sides would use that same Federalist paper against each other. But it was fantastic. The history, you want to hear what they thought, the history of the Greek and Roman republics, the Venetian Republic, and on, the Dutch. Powerful stuff on here in history. And they're pulling out Grotius and Vattel, because they're dealing with international law type of aspects like this. So you can kind of understand through all of this why Missourians are really ticked off. But it's an unbelievable debate. So I'm going to end there so we can have questions, but you got to read the book to get the rest of it. This is the most, of all the books, this is the most fun, because it is amazing the arguments for and against the Talmadge Amendment. And obviously we know we do not get the Talmadge Amendment. It passes the House all the time, the Senate never, hence the compromises. And so that's the reason we got the Thomas Amendment, 3630 line. Missouri is above it, but we get to come in slave. So, and there are some arguments, because they're hearing rumors from Missouri, where overwhelmingly non-slave owning, but very pro-slavery. So that was a big topic. But there were fears of arguments that if Talmadge Amendment passes, Missouri will, when they come to the Union, do they have to follow it? They're sovereign. And there's these arguments, go ahead, pass it. When we become a state, it's now null and void. And so then there's arguments of civil war. But powerful stuff. So I know people out there can't ask questions. I was told this goes to 8 o'clock, but it's only about an hour and a half drive home for my wife and I. So we live in St. Charles County, so we cheated. It's not that far here. Does anybody have any questions? I'm a little rusty on this, so I may have to.
Let's do from the room first, but actually someone.
Oh, you can?
Someone is texting me a question. So.
Oh, that's kind of fancy. That's above my pay grade.
Folks in the room first?
Yes.
So between March of 1820 and August of 1821, what was the status in Missouri?
But to us, we're in the Union.
We're in the Union, but we don't.
Right. So I'll just give you an example of that. The General Assembly passed laws. You can go back and go look at the very first General Assembly, and all the statutes passed are all in there. We had court cases because we had a state court system, the state Supreme Court, and all of that. So we Missourians are wily. So imagine this, if sometime during that period, that interim, you lost a lawsuit. Someone went, hey, wait a minute. No jurisdiction, you're not in the Union. Well, there was a federal judge, and I gotta go back and find this, I'm a little rusty. They did pass, a federal judge indicated that yes, every statute passed, every lawsuit is legal. We're in the Union. Because they were established, they just said that. So there's more to that, but basically the General Assembly was there. We passed laws, governor signed them. We were a state in 1820. Let's fight for that. That'd be a Missouri thing, but yeah. So, but we were not allowed to sit our senators we couldn't sit the U.S. representative. We could still sit our delegate because we were a territory. But he refused to answer to anything other than, I'm not a delegate from Missouri, I'm a constitutionally elected representative. So this is a big fight. Keep in mind too that there's another issue, I'm not even getting this one that's part of this. What happens in 1820? A presidential election. Missouri says we're in the Union. Do we count our electoral votes? Now, Monroe became president in the biggest landslide in American history. They didn't need Missouri's votes, but for many of the Southerners, they actually asked in the roll call Missouri's electoral votes, and someone, oh, wait a minute, they're not in the Union. So I mean, there's still a debate of where to count our electoral votes, and some won it, some didn't. So another issue with that. 1820, let's put it on our flag. We're going to start a movement here at the State Archives. Did you have another?
Well, actually, there's one on the internet. I was going to say you might look at the state seal when you leave too.
Yes, true. 1820 on there. So yeah, it's not like we're invading Kansas again or something, people. I mean, it's 1820. We'll go with it. But
right. So Mark Lowe, who's actually a historian and genealogist from Tennessee. Do you know Mark?
No, I do not. I don't think I do.
So he asked a couple questions. So one of those is the migration and importation clause debate here why states started adding those clauses to state constitutions, or the stipulations refusing free blacks migration?
One of the things I do want to say that about free state, the section of Missouri's constitution is not that unique. Other free states had limitations on the movements of free blacks. Illinois had the strongest black code, and it didn't prevent them from coming there and settling. There was a law in the very first assembly of Illinois preventing, you would fine slave owners for coming to Illinois and freeing their slaves. you'd be fined. They don't want them. So there are other states with similar restrictions on free blacks. There are other ones. And Missouri was going to point that out. I'm like, wait a minute, we're not the only ones. There's others out there. But they're sovereign states. It's up to the state legislature to take it from there. So
he also asked, did this debate lead to additional state clauses, et cetera, to protect state clauses or federal discussion to override the sovereignty of states?
I don't know if he's talking about the Fugitive Slave Act is kind of what I'm thinking he might be talking about, personal liberty laws. Because of the Fugitive Slave Clause, states in the North, Pennsylvania, New York, Massachusetts, during the 1820s, after this, personal liberty laws to protect blacks, possibly runaway slaves. Are you a runaway actually? So they have certain rights. So eventually trial by jury, legal representation, stuff like that. So there is some overlap in that. I will say this, to kind of break off from that, the Missouri debates ended forever the emancipation movement, killed it. Now you see the division into abolitionists and pro-slavery apologetics, that slavery now is a positive good. It's not a necessary evil. That's where you get this break. Missouri does that. And the status of free blacks in many northern states deteriorates awfully. New Jersey is one of the worst ones, where they just say prima facie, your color of your skin determines whether you're free or not. Black is slave. So I mean, there's a powerful movement against free blacks that kind of come out of this. So yeah, the emancipation movement getting killed, and then the rights for free blacks deteriorate heavily because of Missouri. The Missouri crisis, not our fault, just a crisis. I hope that answered that.
It looks like we're having more questions from the Facebook page than we are from the audience here. So, any other questions from the audience? There's another question here on Facebook that asks about the connection of the black purchase to these same kind of things. Was there a similar debate?
I'm not aware of anything with the Platte Purchase. For those that don't know, Missouri I don't have a map of it, our eastern border was just straight. So today the Platte Purchase is Platte County. There's a Fort Buchanan maybe, or Andrew County, there's about 5 or 6 counties there that come later into the Missouri. But that's a very good question, and I don't know that because it came later than this book. But if you think about that, it does violate the compromise, because no other territory above the 3630 line, which is Missouri's southern border, can you have slavery above that. Well, you just enslaved people in 6 states, where normally it would have been free. So, powerful argument. And I don't know if anybody argued it. That's something I'd like to take a look at. It's a great argument, yeah.
Last question, if anybody else doesn't have any questions, is, Steve, could you tell us a little bit more about the Missouri Humanities Council and some of the initiatives that you all have?
Oh, boy, that'd take us days. Yeah, we're Missouri Humanities Council. We're a nonprofit, but we're also quasi-governmental. So we are under the budget line, if you will, of the Lieutenant Governor. We do not take any state taxes. We are funded through the non-resident professional athletes and entertainers tax. What the heck does that mean? It means anytime somebody comes to Busch Stadium, whether they beat us or not, we tax them. You get off the plane, 2% income. So, and like when Taylor Swift comes, for my daughter's big Taylor Swift, we tax them. And that goes to the 5 cultural partners. So we have multiple programs. We have our own community grants program. So anybody out there would like to apply for humanities-based programming, we have money for that. Heritage programs are our biggest. For those who might not have heard of the German Heritage Corridor, that's ours. We have one of the staunchest, most powerful Native American heritage programs. We have states like New Mexico modeling theirs after ours, which I like to hear. Civil War heritage, rural heritage is another one of ours, African American heritage. A lot of education programs. We do a lot of commemorative exhibits. We're on the Governor's Bicentennial Commission. We have a major, massive traveling exhibit. I don't even know where it is, but you can go to our website to find it. So we have, the Center for the Book, which is we're kind of the state's leading literary organization. A speakers bureau, so if anybody ever wants to have a local library or bring in speakers, we help pay for that. So we do anything humanities-based. So a lot more programs than that. We also have one of the nation's highest recognized veterans program. We have a writing workshop for veterans. And an anthology we put together. Volume 10 is coming out here soon. So you can go to our website. They're powerful, powerful writings for that. So we've been recognized by the National Endowment for the Humanities for having a leading veterans program. So that's just it. If you want to go to our website and see all the stuff that we do, and we are statewide, so we have 4 offices across the state, so, and a great staff. So just check out our website and see all the great things we do, including stuff like this.
Thank you so much.
Thank you for having me. I appreciate it. Thanks for coming out.